everyone. Today, we begin not with statistics, but with a story of a continent whose forests breathe life into the planet, whose farmers feed nations, and whose future depends on how we govern both. Africa, the home to 1/5 of the world's tropical forests and 60% of global uncultivated arable land, stands at the crossroads between prosperity and peril. Africa is a land of incredible contrasts, from dense forests that breathe life into our planet to farmlands that feed millions and communities that have lived in harmony with the land for generations. It tells a story of resilience. Yet, these landscapes face challenges: deforestations, drought, and growing pressure on the people who rely on them. Today, we are here not to focus on what is lost, but on what is possible. How can governance, law, and policy guide our forests and farms toward a future where both nature and people thrive? In the next few minutes, we'll explore the current realities, the hope embedded in innovation and community-led solutions, and the role of governance in shaping Africa's climate future. Africa's climate story is one of injustice, contributing the least, yet bearing the most. Floods submerge villages in Mozambique, while droughts scorch Ethiopia's fields. The cost is not just economic, it's cultural, ecological, and deeply human. So, as you can see in the slide, we have carbon absorption, and for forest loss crisis and the challenge in the governance law. So we gathered some values over 1.2 billion tons of CO2 annually that the basin absorbs, making it a critical climate regulator for the entire planet. We already lost 4 million hectares of forest every year due to logging, mining, and agriculture expansion. These forests are more than carbon sinks. They are peacekeepers, rainmakers, and homes to millions. Yet deforestation continues at a staggering pace, driven by both global demand and local survival needs. The future of Africa's food lies in how we farm today. Farmers stand on the front lines of adaptation, balancing ancestral wisdom with modern innovation, from agroforestry in Kenya to climate smart rice in Senegal. This is where the law steps in or sometimes step back. Africa's forest and farming futures hinge on governance: who owns, who manages, and who benefits. Customary laws often clash or coexist with formal frameworks, yet both are essential for resilience. As you can see, we have gathered some other important facts on the women land rights. Women produce about 40% of food, but they own much less. Circa 15% of land they cultivate. So it's a huge difference between them. Africa's climate generation, we have youth under 25 making up 60% of the population, the continent's most abundant resource for change. Just as begin with voice, Africa's women and youth are not just victims, they are visionaries. From land restoration movements in Niger to youth-led forest monitoring in Uganda. They are redefining governance from the ground up. We have also gathered information about how to integrate climate law. And we think that we should merge climate law, environmental justice, and indigenous governance into cohesive frameworks. We want to build transparency and equity into carbon trading systems to benefit communities. Embedded climate adaptation as constitutional rights in national and trade policies is what we think it's most important to obtain for the rights. And we arrived in the very last slide of our presentation, and we put the question, how can legal and institutional innovation accelerate Africa's climate resilience? Because governance is not just an abstract idea, it's a living system. It's shaped by people, power, and purpose. So the question before us is not whether Africa can adapt, but whether we can govern that adaptation justly. As we move to our legal panel, let's reflect. Governance, it's a promise, not just policy. The promise that Africa's forests and farms can thrive together, not in conflict, but in harmony, if the law serves both nature and people. And now I would like Elliot to step in to take over. So Elliot, over to you to start with the main topic with the questions. Thank you.
Thank you, thank you. Good morning, good afternoon, good evening, depending on your location. From Baku to Belém, from Belém to all over the world, we are celebrating today the climate law and governance. It's a big day. So I'm happy to join you and to moderate, and we are very happy to welcome our panelists and discuss on some questions. As we look back on the first decade of global efforts, there are several key lessons that can inform how law and policy capacity building can better contribute to the Paris Agreement implementation in the coming years. Today we have the topic governing forests and farming in the future in Africa. So let me first ask a question to one of the panelists, Mr. Gervais Masdou. Can you please tell us what legal and institutional reforms can strengthen participatory governance and ensure equitable access to land and resources for women, youth, and indigenous people? Over to you, Gervais.
Yes. Okay, good morning, good afternoon, good evening, everyone. It's a pleasure for me to be part of this panel, and I'm Gervais Itomadou. I work for the Economic Community of Central Africa states, and I'm coordinating the Regional Climate Action Transparency Team for Central Africa states. And I'm also vice chair of Working Group 3 for IPCC. So I think that we have actually facing a big challenge in the global action of climate actions. Do you know that based on the last report prepared by the UNFCCC conventions, based on the commitment on the submission from country on the NDC, we're still far on the way to reach the Paris Agreement goal. And as we are talking about climate actions, it's clear that actually all of parties, all of stakeholders are talking about just transitions. We want to implement climate actions in our countries, in the world, but it's important to be sure when we are implementing these actions, we are taking care of all the stakeholders, this issue of women, of YAV, and of indigenous people. And I want just to share with you a little bit on the challenges that we have in Central Africa region, for instance, on the issue related to legal aspect, regulatory aspect, and institutional arrangement. We just finalized the gap assessments in Central Africa region in all our countries on what is missing, how countries cannot report properly on climate actions that have been doing in their countries, because we are trying to contribute to build capacities for countries in order for them to be part of the announced transparency framework in the case of the Paris Agreement. And it's clear that all countries agreed that they must have a strong legal and institutional arrangement in order for them to be able to report. It's clear, for instance, that most of the countries agree that there is a important piece on this way that is missing. It's related to the climate law. Most of our countries don't have climate law, and parties think that it's an important thing that we must address, actually. And also the issue of institutional arrangement. If you have this climate law, you are supposed to have a strategy, and the strategy must suggest in institutional arrangements to set up or to implement all these strategies. Then it's clear that we still have some gaps on this issue. And also I would like to share with you that in Central Africa region, for instance, we have a participatory process on the management and conservation of our forests. We have institutions that are set up in the region that strengthen capacities for IPs, for instance, for CSOs as well to participate in the process. And I think that if in Central Africa region, we already have this framework that allow IPs, YAF, and women to participate in the process, there is the issue of the resources for them to participate effectively in the process, because there is a window for them to participate, but in the other sides, they don't have capacities. And you know, a participatory process, it means a lot of resources, and these are kind of the resources that are missing. And this is the issue that we have in our region. We can have, myself, for instance, I have custom to organize ministerial meetings, steering committees for many activities in the region. We can have a space for IPs. We can have a space for women. We can have a space for YAF in the table. But what kind of information they are bringing in the table? Otherwise, I'm opening this window just to remind all of us that we still have this kind of challenges. We can have a legal and institutional arrangement that allow these participations, but they come in the table without capacities. I prefer to stand here for the moment, and I'm ready to continue sharing some experience during this call. Thank you very much.
Thank you, Java from Hub Transparency. Now we follow to hear someone from Legal Response International. She's an advocate, Mara Wenderbu. We want to know about you. Can you contribute and tell us how can climate law integrate traditional ecological knowledge and right-based approaches to enhance resilience and Paris Agreement alignment? Over to you, Mara. Thank you.
Thank you very much, Elliot, for inviting me to contribute to this roundtable. Whilst I'm not an expert in the specific issues of the African continent and its diverse regions, I can talk about climate change law more broadly, and as you mentioned, like answer to your questions. So I'm talking to you today from COP30 in Belém, where we have witnessed a couple of protests by indigenous peoples on the sidelines of the conference, expressing the need to be heard. So I think this question is very important and very interesting to discuss today. And so regarding the integration of traditional ecological knowledge, the source of climate science and knowledge and what is understood as best available science must be examined. So indeed, at the IPCC, some states have been trying to undermine the consensus of the IPCC of the science because arguing that a lot of the scientists are from the global north. And that's some debates that we've heard at the COP or at the SBs already in Bonn, and especially in relation to the global stocktake. So, but at the same time, the International Court of Justice, in its advisory opinion on the obligation of states with respect to climate change, has stressed that the IPCC and its reports consist of the best available science, and it must be applied in the context of climate change. In addition, it also underlined that the discussion of states with respect of the formulation of the NDCs has to be done in accordance with this best available science, including the 1.5 degrees Celsius threshold. So this leads to, it shows the importance and the eminence of the IPCC. And so it also shows that the IPCC has to integrate, of course, the traditional ecological knowledge and indigenous and local knowledge in its assessments and reports. And that it has been working towards that goal, towards enhancing this integration of different knowledge systems, and to also sort of respond to these legitimacy or credibility questions that have been raised. And concerning the rights-based approaches and how they can be aligned better to the Paris Agreement. So these must also be integrated at the local level. And so, for example, the Inter-American Court of Human Rights and the ICJ in their respective advisory opinions on climate change, they have linked the right to life to climate change obligations, and really shows that a rights-based approach is important to protect human rights at local levels and national levels. And I would also like to repeat what Simon Steele, the UN Climate Change Executive Secretary, said yesterday about the importance of free, prior, and informed consent, but also the care principles that were developed by the facilitative working group of the local communities and indigenous peoples platform, which are co-creation of pathways to enhance engagement of local communities for the benefit of all, but also knowledge system complementarity. And so these care principles have been adopted by the platform and are important as well to integrate traditional ecological knowledge and rights-based approaches that take into consideration these affected communities. And similarly, procedural rights. So I think it's important to stress the customary international legal obligation to perform environmental impact assessment, because that's often not really directly talked about when you talk about climate change. But I think, again, because I've studied the advisory opinions a lot, the ICJ, but also the ITLOS, the International Tribunal on the Law of the Sea, have stressed the importance of performing environmental impact assessment, and these take into consideration both affected communities, so that would be local and indigenous peoples, but also affected communities in neighboring states. And so they have a say, they can actively participate in the decision-making in this process, and thus also have a way of, contributing to the laws and reducing harm made to the environment and ultimately climate change. That's it for my contribution. Thank you.
Thank you, Mara. Thank you. Now we move to the next question to Mr. Gervais. Would like to know from you, Gervais, what mechanism ensure transparent, just, and inclusive adaptation, finance, and carbon initiative? Thank you. Over to you, Gervais.
Yes, Elliot, thank you very much. I hope that you can hear me because we are here in the COP and there are some noises. I don't know if you are receiving these noises as well.
Yes, we hear you very well.
Okay,
yeah, thank you.
Thank you very much. So, first of all, it's important for all of us to know that there is existing financial mechanism. We have the GEF, we have the Adaptation Fund, we have a GCF, and we have some bilateral initiatives that exist and that support finance and carbon initiative. And also we have these carbon markets. There are many. We have Article 6 and so on. I would like to remind to all of us that when we see the ETF, the Enhanced Transparency Framework of the Paris Agreement, there is a provision that developing countries must report on their needs and on the support received. This means that when our developing countries are producing their biannual update report, they are supposed to report clearly on their needs for finance and on the finance received. This is one. And on the other side, developed countries that are supposed to bring resources, they must also report on what kind of resources or funds they have been mobilized from the country to support developed countries. This is the first step that all of us must be aware. You can't go online, you can tap even European Union, even which developed country you want. You can check the biannual transparency report. There is a component where those countries report on what resources has been mobilized on the past 2 years to support climate change issues from developing countries. This is one. And from us as developing countries, this is part of one of my job on the Regional Climate Action Transparency Hub. We are supporting developing countries, for instance, Central African State countries, to set up a mechanism at national level that are support these countries to track climate finance in the countries and to report. This is one of the job that we are doing actually and in the region. It's clear that if you go in our countries, you can see that there are many institutions, even many international NGOs that receive climate finance for the country, and countries are not aware on funds that can be received by them. And then it's important to have this mechanism at national level, and then for sure to have this in place, we need regulatory framework at national level that oblige those stakeholders, those technical partners or financial partners to give information to the people who are in charge to report. This is what I can share for you. And then if you have this reporting system at national level, for sure, the submission of national report, even biannual update report, it's also a participatory process. We must be sure that all stakeholders are involved when the countries is adopting the report to be submitted to the UNFCCC Secretariat. This is what I think that we must be aware that there are some things that we are supposed to do in our country, and also the issue. There is existing information. I was in an event with media people. I talked to them. You are the one who are supposed to go and look for information. You go on the website, you check informations. How many developed countries reported on the finance that they are bringing to developing countries? You are not doing this job. And then you come here, you look information, you are only complaining, oh, we are not receiving the resources. But there are a way for you to get this kind of information and then to share information with your stakeholders. Yes, thank you, Elliot. I don't know if you are satisfied with this kind of. Thank you.
Thank you so much, Gervais. Thank you to show us first how climate law and governance play in securing climate justice. Second, how can governance reform foster resilience and restitution for climate loss and damage in the most climate vulnerable communities worldwide? Third, how can stronger climate law and governance efforts to achieve the UN Sustainable Development Goals? Thank you. Now we turn to Mr. George Fortas. He's a lawyer and a member of the Environment Lawyer Network of Central Africa. He's based in Angola, and we welcome him to tell us about the first question. As we ask to our panelists, George, can you tell us what legal and institutional reforms can strengthen participatory governance and ensure equitable access to indigenous peoples? We know that our audience are speaking many languages. Let's welcome our George and speak in Portuguese. Obrigado. Over to you, George.
Good afternoon, folks. I will speak in Portuguese. Boa tarde a todos. O meu nome é Jorge Fortes Gabriel e, como disse o Elliot, sou advogado, pertenço à rede de juristas ambientalistas da Comunidade de Estados da África Central, pertenço em Angola à Associação Angolana do Mercado de Carbono. É para mim um grande prazer falar neste fórum, sobretudo num contexto em que comemoramos 10 anos do Acordo de Paris e num contexto em que estamos a realizar a COP30 sobre o clima no Brasil. Nós vimos que, com a apresentação, a primeira apresentação e com os slides, que o continente africano apenas é responsável por 4% das emissões e, ao mesmo tempo, tem o poder de sequestrar cerca de 1,2 bilhão toneladas de CO2. Entretanto, é o continente que sofre com 50% dos danos ambientais, onde vivemos climas extremos, desde enchentes a seca severa. É um continente rico em florestas. Entre nós, em Angola, temos pelo menos, estamos situados em 2 biomas muito importantes. A norte, a floresta tropical da Bacia do Congo, e na parte leste, e que abrange 11 países, temos a floresta do biombo. Uma e outra são florestas que estão sob stress. Eles vão sofrendo degradação, vão sofrendo uma acentuada diminuição por fenómenos como agricultura, assentamentos humanos, o uso da floresta para o comércio e também para o carvão. Então, muito tem de ser feito pelos mecanismos da lei e da justiça para que se possam preservar as nossas florestas em prol do clima, não só nosso, como todo o mundo, como também para que as populações possam beneficiar das ações tendentes a preservar o meio ambiente. Então, é muito importante que haja mecanismos como avaliação de impacto ambiental e social de forma reforçada. É importante que a lei exija que as avaliações de impacto social e ambiental em grandes projetos como energia incluam uma avaliação de impacto climático claro. É necessário que haja o consentimento, que haja a palavra daqueles que vivam no mesmo local. Uma vez que a construção de uma barragem ou a colocação de grandes painéis solares pode afetar a comunidade, pode a comunidade deixar de ter benefícios do próprio ambiente. Então, é necessário que haja esta avaliação, em primeiro lugar, e que os órgãos de justiça, os órgãos legislativos, tenham isto em devida conta para que não aconteçam arbitrariedades. Muitas coisas apenas se vê a questão económica e deixa-se de parte o social e o ambiental. É necessário a criação de fundos nacionais de adaptação e é preciso que tenham forma legal. A criação de fundos climáticos de adaptação com estrutura legal transparente que canalize receitas de impostos sobre o carbono, os mercados de carbono ou as receitas de projetos de mitigação diretamente para as comunidades mais vulneráveis, como, por exemplo, financiamento da agricultura resiliente, realojamento de comunidades costeiras, etc. Muitas vezes há a tendência de se fazerem grandes projetos, desde projetos de mineração, projetos hidroelétricos ou outros, em que não se tem em devida conta as populações, as questões sociais das quais essas populações podem ser prejudicadas. É preciso estruturas de partilha de benefícios em projetos de carbono. Portanto, como regula o artigo 6º, nos seus pontos 2 e 6, 2 e 4, deve incluir disposições legais que garantam que uma percentagem obrigatória da receita dos créditos de carbono seja reinvestida em ações de adaptação a nível local ou redistribuída às comunidades que suportem o projeto. Este tem sido um dos grandes defeitos, na medida em que projetos de carbono muitas vezes não se têm em conta as questões ambientais e também os benefícios que as populações locais devem beneficiar, portanto, em prol destas iniciativas de carbono. É necessário uma legislação de proteção dos defensores ambientais. É preciso que haja leis que protejam os ativistas, os líderes comunitários, os advogados que denunciam a inação climática ou a violação dos direitos humanos em projetos ambientais. Muitas vezes os ambientalistas estão em contramão com as políticas do governo, onde os governos muitas vezes têm maior atenção nas questões económicas e deixam de parte as questões sociais e as questões ambientais. Então, é necessário que o Poder Legislativo, e cabe a nós, muito em particular, nós os juristas ambientais, defendermos que deve haver leis de proteção a todos aqueles ativistas que lutem pelos direitos ambientais. É necessário também que a lei preveja que haja uma equidade intergeracional. As leis climáticas devem ser para gerações presentes e para gerações futuras, porque depois de nós, outros virão e todos têm de viver e viver bem à custa das riquezas do país e têm de viver num ambiente saudável, como prescrevem todas as constituições, ou pelo menos quase todas. Bom, por agora é o que eu tinha a dizer. Portanto, é um grande trabalho que o Legislativo, o Judiciário e todos nós, os juristas ambientalistas, temos pela frente para uma transição justa, para um clima justo e para que o clima sirva efetivamente às populações, sirva à sociedade. Espero que tenham todos tido uma tradução e fico por aqui de momento. Muito obrigado.
Obrigado, Advocate George. Thank you so much for your contribution. And now we turn to, it's time for taking some questions from Q&A. I would like to ask my colleague, Camelia, to give us, to take some questions so that we can move forward. Thank you.
Yes. So, do we need provisions in the Constitution to protect forests? Is a question from the audience. If it's possible from the participant, from the advocate Mara, to provide with an answer. Thank you.
Thank you. So I don't know from which country the question emerged, but I think it is an interesting legal question. As we know, there's a lot of rights of nature movement. There's a movement of rights of nature that emerged, especially in Latin America. It's very prominent here. And for example, in Colombia, after climate litigation case, the Colombian Supreme Court gave legal rights to the Colombian Amazon forest. So it is protected now in the Constitution of Colombia. And in similar cases, I think in New Zealand, a river has now also legal rights in the Constitution. So these are very interesting legal structures. And it is tricky because it has to be then legalized through the Constitution or through a legal text adopted by the Parliament or the President of the certain country. But it is a way of protecting the forests. Yes. Thanks.
Great. Thank you very much. So in my perspective, responded to the, yes, please.
Okay, thank you. I don't know if I understood properly the question, because the question is related to the provision to protect forests, provision of finance to protect forests and to make conservation. I hope.
It's to protect the forests. Yes. So the question is about how to protect the forests with the support of the law. So to be more, I think, strict and right to protect the forests.
Yes. So, of course, I think that I am a Red Plus negotiator. It's clear that this is one of the issues that you are dealing for. We negotiated for more than 10 years under the UNFCCC to get some decisions for implementation of the RED Plus. And I remember that it was clear on all the decisions that we have under the UNFCCC, under the COP, it's clear that we must support forests. But the issue of RED is that we have many constraints for a country to demonstrate how they have made reduction of emissions in their countries. And also, it's also next to the what we call carbon on forest sector. And then it's clear, for instance, in Central Africa, we are clear that when we sell our forest carbon credit at $5 or less than $5, it's not enough. This cannot come to bring resources to conserve a forest because we spend more than $5 to protect this forest than what we are receiving at the end. And actually, just to confirm with participants, with people who are online, that there are existing mechanisms. If you show that your forest is vulnerable from the impact of climate change, for sure, it's an adaptation project. And this one can be founded through existing mechanisms in the UNFCCC or climate finance. And also, if our countries, if our forest is emitting a lot of CO2, it's important that this can be eligible under mitigation project finance, and this forest can receive finance. I know all these mechanisms can look hard, not easy for a common citizen. But under the GCF, for instance, we have this window called readiness window. This mechanism has been set up to support countries or stakeholders to prepare bankable projects. Thus, these countries, these stakeholders looking money to protect their forests, are they aware that there is an existing mechanism that can support them to prepare a bankable project? This is a readiness portfolio under this. And also here in Belém, it's clear that we have this new initiative called TFFF that has been led by the president of Brazil, President Lula. And then it's clear that under this new mechanism that are already starting to receive some announcement, it's clear that this new mechanism don't want to go through existing mechanisms. We want resources to protect forests because forest is vital for people. Forest is important for regulating climate change. And also there are many announcements with private sector, with a coalition of rainforests, with people, some bank, for instance, Dutch bank are engaged to buy some forest credit. And then this is opportunity that actually exists for forests. Thank you very much.
Thank you very much, Gervais. I have another good question from the audience. What best way to elementarily define climate justice from African perspective? And with that, maybe Jorge or can support
Can I
us?
take it?
Yes, please. Okay, go ahead.
Yes.
Go with you.
Thank you. Nowadays, we know that several African countries have put in place frameworks and measures that enhance the adaptive capacity of the climate response system. This includes robust climate policy frameworks such as legislation. However, very few African countries have stand-alone climate change legislation. We can mention, for example, Kenya, Benin, Mauritius, Uganda, Nigeria, Gabon, South Africa, Zambia. Some countries in Africa rely on the national green growth strategies to coordinate climate change response in the jurisdictions. For example, Ethiopia Climate Resilient Green Economy Strategy and Rwanda's Green Growth Strategy and Climate Resilience are climate documents that informs Ethiopians and Rwanda's climate actions, respectively. Other countries such as Ghana, Democratic Republic of Congo, and Tanzania has incorporated climate change provision within the existing environmental legislation. The majority of countries lack a legal framework on climate change, but today we have a model which is put in place. A model climate change law for Africa was developed to assist African countries to customize and enact their own respective climate change legislation based on their national circumstances. We know that we have a support of Agnes, I can mention, the African group negotiators support, who did a great job in accompanying countries and also advise countries and put in place some networks of parliamentary, of lawyers in order to implement what the Paris Agreement requires. Thank you. Over to you.
Thank you. We have other two questions. It's about the translation of this valuable information. I'm sure we can do that after the session is closing. We are thinking also to do for the closing session a summary to share with the participants via email. Thank you very much for all these questions. I would like to continue with closing notes. First of all, I would like to share with you to present myself because I was a bit nervous and started directly. So I am Elena Camelia Papuk. I'm a Romanian expert, European, working in Bucharest, Romania. I work for European executive agencies as external expert in innovation projects and all related with technologies and for several industries, but all related with sustainability and climate change and how we address this to have better results and better life. So I will start now with the closing session. I prepared some responses to the questions and included a part of responses from what we received in our session. So I want to share with you right now, and let me know if it's okay. Okay. I trust everybody can see that. Just a second, because, sorry, okay. I will do it again, just to make sure. And, okay, sorry. As I said, nervous. Okay. Good. So the first question that we discussed, it was about legal institutional reforms, if it can be strengthened participatory governance and ensure equitable access to land and resources for women, youth, and indigenous people. So what is important is that we agree that we need to do a gap analysis on how countries can do climate reports to understand better their capacity. So it was clear that most of the countries don't have a climate law, and they should address it better, because they have to detail better their strategies to implement a climate law. So and this is important. So we have to recognize and legally protect all tenure systems from customary, communal, and individual. We need to create these use-friendly land access pathways, including leases and land banks. Of course, we need to do this legally guarantee free, prior, and informed consent for Indigenous people. It's important to establish a transparent community, inclusive land and resource governance bodies to integrate customary authorities into national land systems with accountability rules. There is important to mandate transparent licensing, contract disclosure, and fair benefit sharing. Use measurable equity indicators and independent monitoring to enforce reforms. In terms of the question number 2, how can climate law integrate traditional ecological knowledge and rights-based approaches to enhance resilience and Paris Agreement? It was mentioned that it's clear that we need to do this gap analysis, but we need to legally recognize and protect traditional ecological knowledge as a climate relevant resource. We need to integrate indigenous and local adaptation practices into national adaptation plans. We have to establish rights-based safeguards in mitigation projects, including carbon markets, to protect land, water, and resources rights that enable traditional ecological knowledge-based resilience. Sorry. And of course, to create these co-management frameworks linking state agencies with customary authorities, to mandate equitable benefit sharing for climate and carbon initiatives. And of course, to align all these climate actions with local commitments. In regards to the last questions that we discuss, what mechanisms ensure transparent, just, and inclusive adaptation finance and carbon initiatives? Has to be established clear legal standards for transparency, disclosure, and public reporting of climate finance flows. It was clearly said that in Europe, we have clear legislations, frameworks, and so on. We do have also in Africa, but they are not so transparency. There is not required by law and not monitored by law this disclosure. Of course, also in Europe is not legally, let's say, very strictly monitor this disclosure. However, it's critically important to be done, at least in my opinion. So we need to require free, prior, and informed consent for all carbon and adaptation projects affecting communities. Has to be created multi-stakeholders oversight bodies with women, youth, and indigenous representation. It's important to use open, accessible registries for carbon credits, contracts, and benefit sharing agreements. Yes, and it is also done most of all in Europe and parts in wealthy states, let's say, mandate independent audits and third-party verification of finance and project impacts. And we should start doing this also in Africa countries as well. Implement equitable benefit sharing frameworks with community managed funds. Provide grievance and remedy mechanisms that are accessible and culturally appropriate. Build safeguards against corruption, capture, and land dispossession. The financing eligibility to human rights compliance and inclusive governance standards. All of that are important and will ensure the transparent, just, and inclusive adaptation, finance, and carbon initiatives. Thank you for hearing me, and this is from my side. If anyone has questions or closing notes, happy to. Yes, please. Yes, yes, of course. Yes, we have a question from. Yes.
Can you hear me?
Yes, please. Yes, we hear you.
Thank you. Thank you very much, Camelia, and thank you very much to the panel for the very insightful remarks. Maybe question. First of all, I would like to send my apologies and regards from my team lead, Dr. Mukwaya. We were running a parallel event, so he was unable to join us. But my question to the panel is just maybe riding on one of the questions that has also been asked in the chat, which was around how some people are sometimes evicted from their areas in advancing environmental actions. So my question to the panel is, how best, or what are some of these pertinent features or elements in public participation which will drive and enhance effective stakeholder engagement to ensure that we're not facing some of these challenges which result from climate action or environmental action, which may sometimes actually have some detrimental effects. And if possible, also for the African advocates, Elliot and Jave, if they're also able to contextify it to the African context and see how Africa in itself can advance effective principles, especially public participation. So over to you, Camelia, and thank you very much for the opportunity.